Morning, everyone. My name is Jason Witt, and I'm your 2024 President of the Colorado Association of Realtors. I wanted to thank you for taking time and joining us today to learn about these important changes that impact our industry. I also want to thank you for your patience as we're letting the floodgates open. There is 5,000 of us on this Zoom call today, and so as we're working through things, people are starting to come in and pour in. So please be patient with Holly and her group as we work through this, but we'll get everybody in. But before I begin, I have a few housekeeping items to go over. Today's webinar does not have CE credit, which is why we have disabled the camera feature for everyone. So if you have any questions, please submit those questions in the Q&A box on your Zoom control ribbon, which is right at the bottom of your Zoom screen. So today's webinar will be compliant with antitrust laws. Any questions submitted to the chat box that violate antitrust laws will be deleted immediately. Any individuals who continue to violate the laws will be removed from the webinar. So an example of the violation of an antitrust law would be a statement like our individual company, or what our individual pricing is, or what our business policy is, and customer strategies and or practices. For example, our company charges a minimum commission of a number, and you say a number there. If you wish to provide an example in your question that includes a commission rate, please do not enter a number. Please use the letter X. For example, if I were to set up my commission at X, how would I notify the sellers of my rate? So if you have any technical issues, please submit them in the chat box as well, and Holly and her staff will assist you as quickly as they can. This webinar is being recorded and shared to our YouTube channel, Colorado Realtors. CAR staff has created a page with resources about contract changes and lawsuit update. The link is posted in the chat, and we encourage you to utilize this resource and share it with your fellow realtors. Now, without further ado, please help me welcome Colorado's favorite real estate attorney, Scott Peterson. Scott serves as general counsel for the Colorado Association of Realtors, the state's largest real estate trade association. CAR is dedicated to serving over 26,000 realtors and 28 local realtor associations statewide. Scott, the floor is yours. Take it away, my friend.
Awesome. Thank you, Jason. I appreciate those opening remarks and kind words. I don't know about favorite, but anyhow, I'm very fortunate and happy to be able to work with and support so many of you guys, my friends. I'd like to say I can see so many faces, but I'm just looking at my silly mug here. Unfortunately, that's one of the downsides to these webinars is I can't see everybody's reaction. But thank you guys for being here. Obviously, just based on the reception we had for this class and others being offered, this is something that is certainly important. And kudos to you guys for acknowledging how important it is that you're aware of some of these changes taking place. As most of you know, in a normal year, and last year as well was a little bit of an exception for different reasons. When we release, or when the Division of Real Estate, the Real Estate Commission releases their forms in Colorado, it's usually done on January 1st. And the red lines for those forms are typically released sometime in September, October. And the bottom line is that between the being able to view all of the new contract updates and forms that the Real Estate Commission is releasing and their actual implementation or mandatory date, there's usually 2.5, 3, sometimes 4 months to get your education and to figure out what's going on and have an understanding of how things are going to work come January 1st. Well, obviously, because of the practice changes, the MLS practice changes that are going into effect, not later than August 17th. And I think most MLSs in the state of Colorado that I'm hearing from are doing kind of August 15th is when they're going to implement these things. But because of that, the forms for the second year in a row got released very early in the year, and very quickly after they were approved by the commission. Ultimately, all of the changes, and the commission only approved the changes about, I think, about 3 weeks ago now. And so the kind of scramble to get these things out, get some education provided, and some information on how to use these things has been a bit of a frenzy. And you know, that's a good thing. It's a good thing that people are talking about. So what I'm going to do here today is focus on the changes to the contracts. And we're going to be talking about 5 documents, 4 commission approved forms, and 1 kind of unique form that I'll explain when we get there. The changes to the contracts that are really being primarily driven by the N.A.R. settlement agreement and by the MLS practice changes that are going into place. All of the contracts to buy and sell in Colorado, those were on the original docket for this year to be reviewed and updated by the Forms Committee and to be implemented, would have been January 1st of next year for a 3-year cycle like they normally are. So the Forms Committee was already at work on the contracts. It was fortuitous in that sense that you know, the timing in some ways with regard to this, but I'm not going to cover some of the other changes now. I'm going to do a Legal Bites video at some point in the next few days, and we'll put that up on our YouTube channel. And I'll do an extensive or more extensive breakdown on the other changes. This session is primarily, or is 100%, I should say, focused on the practice change implications and the 5 documents that you guys need to be aware of as you're implementing those changes they're coming very quickly. Like I say, in most cases, August 15th. I'm going to share my screen here so I can stop looking at a big full screen version of myself and put this up. So before I get going in the content, I need to give some background. When I originally wrote this PowerPoint, I was thinking, I'm so enmeshed in this, and I know many of you who are on this webinar have been paying a lot of attention ever since March 15th, when the N.A.R. settlement agreement was announced and released. And these practice changes really were issued. You know, I've been living and breathing this stuff, and sometimes I overlook the fact that not everybody's doing the same thing. And so I'm not going to go into a detailed settlement agreement breakdown, but I want to make a few what I consider to be very important points as it relates to some specific terms of the settlement agreement, and make sure that everybody on this call, and encourage you guys to be clear with regard to anybody you're talking to, the distinctions between where these changes are being implemented, and to make sure that you're very clear with that with consumers as you're talking to folks going forward. So settlement agreement entered March 15th, 2024 was when it was signed. It's been preliminarily approved. And we know, you know, the numbers, a lot of money on the table that N.A.R. is settling for, of $418 million. But that's the money part, the financial piece of things. The thing that's brought us here today really is the practice changes, part of the relief that was agreed to. And in N.A.R. signing the settlement agreement, they basically settled out American MLS systems, realtor associations, brokerage firms, the vast majority of both small and large brokerage firms, everybody involved. But in order for that settlement to be impactful or to cover you, you've got to be a realtor member on August 17th, coming up here in 2024. And for the MLSs to be protected under the settlement agreements, they had to opt in to the settlement agreement independently. They had to sign in their own opt-in agreement, agreeing to abide by certain provisions, certain practice changes. And so it's important to be clear that the settlement agreement, the terms of that, and some of the things we're going to talk about, these are not being imposed by the realtor associations. They're certainly not being imposed by the Colorado Division of Real Estate or Colorado statute or license law or any regulatory framework. These practice changes are being imposed on you all, day-to-day, you know, rank and file MLS participants by your MLSs. And the practice changes do not just apply to realtors. The practice changes apply to anybody who is a participant with any MLS that has opted into the settlement agreement, which to my knowledge, I think we have 13, 14 MLSs in the state of Colorado. To my knowledge, all of them did opt in. And so these changes, these practice changes, apply to everybody in the state that is an MLS participant, not because of state law or any other jurisdictional body. And so please understand that going forward. Why is that important? Well, we know that the biggest practice change that everybody's talking about is the elimination of the offer of compensation, or any references really to any offers of compensation anywhere on the American MLS system, including every one of them in Colorado. There will be no more offer of compensation that is available and shown to you as a potential cooperating buyer broker. Won't be shown to consumers through syndication sites. It can be nowhere. And as I've said many times, I think the MLSs will be obsessively enforcing that rule. And so to the extent that there's coded language, or people are uploading documents to the MLS that might indicate compensation, or any, as I would refer to them, shenanigans, I don't think that the MLS is going to put up with any of that for any period of time. So assume that that is not going to be available to you. And that's the biggest change that everybody's been talking about that will become into place. And like I say, the vast majority of MLS is August 15th. The other thing that has caused a little bit of confusion, that's a term of the settlement agreement, is this concept of prior to an MLS participant working with a buyer or touring properties with a buyer, they are supposed to have a written agreement with that buyer. Buyer touring agreement, as people have been referring to it. So what I would say about this is it is some of you have we've had some conflict, I think, in terms of maybe the Division of Real Estate's perspective on the ability of this settlement agreement or MLS policy to impact. As we know in Colorado, there is no requirement in the state of Colorado that a buyer executes a written agreement prior to working with a broker. There's no requirement on the broker, because we do know that in Colorado, you can default into a transaction brokerage relationship with a buyer, not through an agreement, but through a disclosure. And that's what we would refer to as the broker disclosure to buyer. That's not an agreement, that's merely a disclosure. And so that broker disclosure to buyer in and of itself does not satisfy what N.A.R's perspective is, or your MLS's perspective at this point, on a written agreement, because it's simply not an agreement. So at this point, it feels very much like that requirement is that N.A.R. is continuing to move forward with their interpretation of the settlement agreements that the MLSs have signed, that a written agreement is required if you're an MLS participant in Colorado, irrespective of the fact that state law doesn't require it. In other words, it's going above and beyond what state law is doing. I think the Division of Real Estate has highlighted, as many of you have seen, in several instances over the last several months since the settlement agreement has been released, that that in Colorado, a written agreement with a buyer is not required. And so that has created some confusion to a degree. The good news is we have a solution for something that will satisfy the written agreement. It is not the Zillow touring agreement. It is not other touring agreements that I've seen sort of commonly promulgated out there by other brokerage firms, other folks. Those, under any analysis that I've ever seen, do not conform with our standard form or use of form rules in Colorado. And so it's important to understand that. And I'm going to explain in the forms what document you're going to be using to satisfy what will be your MLS requirement. But as you're talking to a consumer about this, and I'll reemphasize it when we get to the document later, it is important that as you're explaining to buyers that they need to sign this written agreement, they don't need to sign that written agreement pursuant to Colorado state law, license law, state regulation, statute, anything. They need to sign that agreement because that is your MLS participation requirement. So that is where that requirement comes from. And it's super important that as you're engaging with consumers, prospective buyers, and in instructing them that you need to get this written agreement executed prior to touring properties with them, that you do not conflate those two entities, MLS and your requirements there, which is 100% of why this exists, versus Colorado Division of Real Estate, license law, et cetera. So with that said, now, the other most important thing I can probably tell you is that you're crazy if you're not getting a written agreement, because another part and a fundamental part of the settlement agreement that's been entered into is that you as a buyer broker are only able to collect at closing the amount of money that your buyer has agreed to compensate you through a separate agreement. So if you're just doing a broker disclosure to buyer, remember, no agreement, buyer is on the hook, owes you nothing. They owe you no exclusivity. They owe you no compensation. They owe you nothing. Your ability to collect anything at closing is zero. Even if the seller or listing brokerage firm is offering compensation, because your buyer is not obligated to pay you, you're not, based on the terms of the settlement agreement, allowed to collect anything. And so getting a written agreement with a buyer is fundamental, I believe, to your survivability, your success in this business, unless you're just an altruistic person that likes, running around with buyers on your weekends and evenings and working on their behalf to not get paid. And so regardless of where everything might land with the timing and the written touring agreement requirements, I can't emphasize enough the importance of you having that conversation with your buyers and getting your buyers' skin in the game early so that you're able to request, require, and collect compensation commensurate with whatever they have agreed to pay you otherwise. And that's another term of the settlement agreement that I think is often a little bit overlooked. So with those things on the table, I want to kind of start here, and we're going to start talking about the contracts. And I deliberated a lot with regard to the ordering of these things. And I think the best way to start this discussion is right here. These forms, by the way, and the last slide, I'll have a link, but they're on the Division of Real Estate's website in their red line format. Most of you probably have already gone and grabbed them. We've got a resources page at N.A.R, and you'll see a link to that on the last slide that we've got here today. And we're kind of aggregating resources that we think will be valuable to you, including access to these forms as well. But these are out. They're released as of, it was about a week ago last Friday. And so they're available. This one is the one you know and all love, the contract to buy and sell real estate, residential real estate, because residential real estate is the big place where this is really impactful. Commercial brokers have been dealing with this for years, right? They haven't had the benefit of an MLS to memorialize an offer of compensation. So they've been negotiating independently their compensation for a long, long time. But with regard to the MLS, this is the first change that is in the contract. And remember, there are other contract changes, not for today. I'll talk about those and do another. We'll just release a Zoom video through Legal Bites at some point in the next week or so. All right. But this is the formative one, and I'm going to set everything up here. So paragraph 29 is being added. Last paragraph of the contract, as you see right there above the additional provisions and attachments, and it is entitled Buyer's Brokerage Firm Compensation. This is only for the buyer brokers, all right? Buyer's brokerage firm's compensation will be paid at closing as follows, and there's 3 boxes that you might be inclined to check depending on what you have in place at the time you are preparing an offer to present on behalf of your buyer. 29.1 would be checked. X% of the purchase price or some flat dollar amount will be paid by seller. Buyer's brokerage firm is an intended third-party beneficiary under this provision only. The amount paid by seller under this provision is in addition to any other amounts seller is paying on behalf of buyer elsewhere in this contract. Okay, so what does all this mean? Number one, this is what you would check in the event that you are a buyer broker, you reach out to a listing broker, and the listing broker might say, well, my agreement with the seller only contemplates my commission and doesn't contemplate a cooperating broker, but they're maybe willing to consider one. You're just going to have to put it in the offer. All right, and I think you're going to start seeing more of that. And in that case, as a buyer's broker, you're preparing the offer. If you've got an agreement with your buyer, either exclusive right to buy, or you have, and we'll discuss it later, but the compensation portion of the broker disclosure to buyer completed that obligates your buyer to pay you X%. If the seller or listing brokerage firm doesn't pay you, then you are free now to put that right in the contract and make it part of the offer. And the seller is obligated through the execution of that offer to compensate you at closing. All right. And then the next sentence speaks to the fact that buyer's brokerage firm is an intended third-party beneficiary under this provision only. What does that mean? It means that you're not a party to the contract, right? You're a third party. The only parties to the contract, as we know, are the buyer and the seller. And so a lot of times, if the seller is going to agree to compensate you through the contract, you need some ability to go and independently enforce that. So let's say you get this executed, seller signs it, agrees to pay you X%, show up at closing, the seller says, I'm not paying them. They were a pain in my rear the whole transaction. I'm not going to pay them anything. Well, if you weren't a third-party beneficiary to the contract, then the only way that you could actually go and collect on the contract would be to bring your buyer in and have your buyer sue the seller and to enforce this term, because the buyer is the party to the contract, not you. But because of this language, it gives you the ability to independently, as a third-party beneficiary, enforce that piece of the contract. If that scenario, God forbid, arises, then you could initiate that on your own against the seller. Wouldn't have to drag your buyer into it. And then the last sentence there says the amount paid by seller under this provision is addition to any other amount seller is paying on behalf of buyer elsewhere in this contract. That's referring to seller concession. So I think that sentence essentially is like, if there's other ways that this is being memorialized, or compensation is being memorialized, either through seller concessions to buyer, or there's any other concessions to buyer for that matter, this is separate from that. So in the event that you've got you're writing a contract, and in the offer this is going under seller concessions, and your buyer is going to be paying you out of concessions that the seller is making to your buyer, but the buyer is still going to be paying you directly, then you wouldn't be putting that in this paragraph there. I think the problem with putting your compensation in seller concessions is how that might interface with the lender in the event that your buyer is actually obtaining a loan. Lenders sometimes might have some concerns just about how it's described. So if you expect the seller to pay you, 29.1 is the best place to do that. 29.2, blank % of the purchase price or blank dollars by the buyer pursuant to a separate agreement between buyer and buyer's brokerage firm. This amount may be modified between buyer and buyer's brokerage firm outside of this contract. So this is where you're disclosing to your buyer and memorializing, essentially disclosing to all the parties, compensation that you're receiving with your buyer. So to the extent that you have an agreement, a exclusive right to buy, and you've got your success fee that buyer is going to pay you, or you've got the new compensation agreement that we'll talk about in just a little bit that your buyer is going to be paying you, then that's where you would memorialize that. And if you look here, it says by buyer pursuant to a separate agreement. So in this situation, the separate agreement is either going to be your exclusive right to buy with your buyer and the success fee contained there, or it's going to be the broker disclosure to buyer that now has a whole new part, the compensation agreement with your buyer. So it's one of those two things. It would go in there. All right. And this amount may be modified between buyer and buyer's brokerage firm outside of this contract. That essentially gives you the ability to change that independently without having to go. If for some reason, you decide you're going to reduce that with your buyer, or maybe increase it with your buyer, you could just modify that separate contract with your buyer directly, and you don't have to go back and then have the parties, both buyer and seller, do an amendment to paragraph 29 just for the purposes of memorializing your change in compensation, because that would then require the seller to make a subsequent agreement, and maybe something's changed in the deal. Maybe there's a backup offer, and the seller's going, no, I'm not going to sign any amended extends. Well, they shouldn't have to in order to allow you and your buyer independently to modify that provision. And that's what that sentence essentially says. And that's what you're going to do if the buyer's paying it. And then the third box is blank % of the purchase price or blank dollars by a separate agreement between buyer's brokerage firm and seller's brokerage firm. All right. This is kind of the how we've been doing it in 99.9% of the cases for a long time, is that only the separate agreement was enough to just be the offer of compensation that's been contained in the MLSs. With that gone now, that changes things quite a bit. And so separate agreement is going to be something that we're talking about a little bit later. But again, it's not part of the contract. So the other thing I want to emphasize here is that you can check multiple boxes. So if the buyer's, if the seller's going to pay you X%, your buyer's going to be paying you Y%, and the listing brokerage firm is going to be paying you Z%, you could have all three boxes checked, and it would all kind of aggregate into the total amount of compensation that your buyer had originally agreed to pay you. But it can't be more. It could be less, but it can't be more. And so Any of these, regardless if you're going to use the seller, if you're going to ask the seller to pay you through the contract, if you're asking the buyer pursuant to your buyer agreement, or if you're going to be asking the listing broker pursuant to a separate agreement as well, the number that you're asking for in the aggregate can only be what your buyer has, through some written agreement with you, agreed to pay you. It cannot be more. And that's a very explicit term of the settlement agreement. So that's the main substantive change that you're getting to the contract to buy and sell as it relates to the MLS practice changes. Very quickly, I just want to point this out in the broker acknowledgments and compensation disclosure. This is the very end, last page of the contract document. It is outside of the contract. It always has been. And so basically, this just had a couple of changes to specify that brokerage firm compensation or commission is to be paid by or is to be paid as specified in paragraph 29 above. So nothing terribly substantive there. But remember, guys, never has that been an appropriate place to secure your compensation. And it's said in there for the last 3 years now, this broker's acknowledgement and compensation disclosure is for disclosure purposes only and does not create any claim for compensation. So putting additional language in this, or putting percentages or dollar amounts in either of the broker acknowledgement boxes, even as they're revised, it does nothing to secure your compensation with another broker, with the seller, with your buyer, with anybody else. And so please don't use it for those purposes. Okay, 1 down, 4 to go. Exclusive right to sell listing contract has some changes. First of all, and you'll see this both at the top of both the exclusive right to sell as well as the exclusive right to buy. This language got tweaked a little bit, not substantively necessarily, but this is more directly on point with the terms of the settlement agreement. Compensation charged by brokerage firms is not set by law and is fully negotiable. So that's what that says now. It is said for many years, people overlook this, but it's always said, what you can see was stricken there. Such changes are established by each real estate brokerage firm. But the settlement agreement got a little bit more explicit in terms of language that they wanted to see in there. And this was an easy change to agree to. So you'll see that at the top of both the exclusive right agreements, same spirit that we've always lived under, which is that it is fully negotiable. All right. So now we're into the substantive change in the exclusive right to sell listing contract. So you'll notice throughout all of the commission approved forms, and even the 5th form that we'll talk about, which is the brokerage firm compensation agreement, we're moving away from commission references to commission and using the term compensation. I don't think that's earth shattering. I think it more reflects, your compensation for performing a service. And so in all of the forms, you're going to see less or no references to commissions, brokerage commissions, but brokerage compensation. It's what you've always gotten anyhow, and it's for the unbelievably excellent professional services that you provide. You're compensated for them, as any of your clients would expect to be for the work that they provide, in their professional lives. So paragraph 7 of the exclusive right to sell, compensation to brokerage to firm, compensation to buyer brokerage firm. So this is what sets up your listing brokerage firm compensation, as well as any offers of compensation that the seller is authorizing you to make to a cooperating buyer broker, not through the MLS, because you can't do that anymore, but through some other agreement or through other advertising outside of the MLS. All right. Seller agrees that any brokerage firm compensation is conditioned upon the sale of property will be earned by brokerage firm as set forth herein, without any discount or allowance for any efforts made by seller or any other person in connection with the sale of property. What is the amount? 7.1. In consideration of the services to be performed by broker, seller agrees to pay brokerage firm as follows. So your commission for sale, or your compensation, for sale is X% of the gross purchase price in US or blank in US dollars. So it's going to be percentage or blank, same as the other changes to the contract there. And then we get into if there's a cooperating broker. If buyer's brokerage firm, 1, procures a buyer, and 2, the transaction results in a closing of the sale of the property to such buyer, seller's brokerage firm may enter into a compensation agreement with buyer's brokerage firm to contribute from the sale compensation an amount of X% or of the gross purchase price or blank dollars in US dollars to buyer's brokerage firm. So that gives you the authorization there to sign a compensation agreement with the buyer's brokerage firm. And the compensation agreement, again, we'll get to that later here in the morning. But that's your authorization from the seller. Now, you're only going to sign that compensation agreement with the percentage that you've been allowed to offer, or the dollar amount you've been allowed to offer to the buyer. Obviously, you wouldn't want to sign anything greater, because that certainly would bind you to paying something more. And you wouldn't want to sign anything less than that amount, because that would be inconsistent with what you've agreed in a separate contract, this exclusive right to sell, with your seller. So you'd have some fiduciary breach issues there. So those two blanks are going to need to line up with what goes into the compensation agreement, again, that I'll put up on screen and we'll talk about in just a little bit. All right. If seller agrees to pay buyer's brokerage firm pursuant to the contract between buyer and seller, seller's compensation to seller's brokerage firm will be reduced by that amount, not to exceed the buyer brokerage firm compensation set forth in 7.1.1.1, which is the paragraph above. So what does that mean? It means that to the extent that for some reason your listing brokerage firm has this agreement and it's going to say X% of the gross purchase price, if the seller accepts a contract from the buyer, in paragraph 29, it says seller to pay buyer's brokerage firm of something of X% or something less than X%, for whatever reason, because it was the way it was drafted, the way it was written, the way it was executed, however, then that amount that they're agreeing to pay you here in, and I'll just go back to it here, that they're agreeing to pay the buyer directly in 29.1, that's going to reduce automatically the seller's obligation to compensate you, the listing broker, in your listing agreement by the amount that they agree with the buyer in paragraph 29.1. Okay, and that protects the seller from not getting somehow doubled up on compensation. They're going to pay you, and you're only giving a lesser amount to the buyer broker, but then they're also agreeing to supplement that through their own. It caps the seller's liability at the total amount of what's been agreed to in 7.1.1 above. Okay, so that's that piece of things, and then lease compensation. I'm not going to dwell too much. It's the same concept that we just dealt with on the sale compensation just above. So to the extent that you're doing, exclusive right to lease agreement and you're listing property, the same theories apply with that. So that's the that, and then just below that in 7.2, and nothing to really talk about here. You can see throughout paragraph 7.2 and 7.3 that references to the word commission gone. Compensation is now being used in lieu of that. Not substantive, but I think important, because again, compensation is what you earn through your professional services, and compensation is what many of your clients understand, because that's their salary, that's their paycheck. You don't get a salary or a paycheck in the vast majority of cases, and so this is how you get compensated. And I think as an industry, it's an important term that we all start to utilize a little bit more. Okay, 2 out of 5 documents complete.
Hey,
now we're going to talk about the, yep.
I'm so sorry to interrupt you. I just want to remind everyone, please do not be putting actual numbers when you're talking about commission in the Q&A box. The questions are available for everyone to be able to see, and that is violating antitrust laws. We are deleting them, but just please, quick reminder, don't be putting in a number percentage. Please just be doing X%.
Thank you, Holly. Yeah, I think, I mean, I get it. I struggle sometimes to talk in terms of X and Y, but some of literally, this is the foundation of some of the behavior that really got the industry into trouble is talking in terms of standard numbers and such. But anyhow, thank you guys for being respectful of that. All right. Exclusive right to buy is the next document we're going to talk about. The third commission approved form that is being modified to address this. Compensation, same thing as this exclusive right to sell right there at the top, right? Same thing as we did there. Now, this is a much more substantive change, though, in your exclusive right to buy than what we did in the exclusive right to sell listing agreement. And I haven't even seen the questions, but I'm certain that somebody has already asked, or many people have asked, because I've had this question a lot. let's say that I enter into an exclusive right to buy or sell agreement August 1st. So on the current set of forms. And I'm still working under that. We haven't found a house for the buyer, and we haven't put a house. My listing agreement is still, we're still looking for a buyer for my for sale listing agreement. So I'm still actively working on this agreement. Do I have to amend the agreements? So here's what I would say to this piece of things. The exclusive right to sell listing agreement, I think you're fine, and you don't, there's nothing to amend, right? I think the only clarification is that you're not going to be advertising the compensation on the MLS, because that's now precluded, but I don't think there's anything to amend in the contract there. Obviously, if for some reason the offered compensation, your seller says, well, now that it's not in the MLS anymore, I don't want to offer compensation, or I want to reduce it, or I want to change it in some way, or I want to increase it, whatever it is, then obviously you need to do on the exclusive right to sell agreement, you're going to need to do an amend, extend, and memorialize that. Exclusive right to buy, a little bit different, and this is what I'm going to talk about here. I think depending on how you check the box before is going to relate to whether or not you need to do an amendment after August 15th or after these MLS practice changes go into effect. All right, compensation to brokerage firm. In consideration of the services to be performed by brokerage firm will be paid as set forth in this section with no discount or allowance for any efforts made by buyer or any other person, unless approved by buyer in writing. Brokerage firm is not entitled to receive additional compensation, bonuses, and incentives paid by listing brokerage firm or seller. That is different. You see this not right here. That's new. It used to say brokerage firm is entitled to receive additional compensation, bonuses, incentives. Now you are not. And this is where it gets back to this point that I really tried to emphasize earlier. If your buyer is not on the hook to compensate you, or if essentially they are on the hook to compensate you zero, then you can't receive anything at all. And that's why this concept of getting a written agreement is fundamental, I believe, to your survival as a buyer broker if you want to get paid. So that's a very substantive change. You can only get what your buyer has agreed to, nothing more. You could take less, but you can't take more. All right. So keep that in mind. And then, so we have this, if you look at 7.1.1 in the buyer agreement, they deleted but not less than, because that doesn't apply anymore. It is X. That's whatever dollar amount or percentage has been agreed to is it. Nothing different. And then we get into another substantive piece here, 7.3.1.1 and 7.3. So this is a section I've talked about for a long time. This is the box if you get an exclusive right to buy, which is really what you should. And by the way, guys, your buyers want an agent, and you can't be an agent without a writing in the state of Colorado. That is illegal. You have to have an exclusive right to buy listing agreement executed by your buyer if you want to perform the fiduciary duties, if you want to be their agent, if you want to advocate for them, or better yet, if they want you to advocate for them, if they want you to fight for them, if they want you to, bang the seller up on inspection resolution items and hammer out the best purchase price and the best deal for them. If they want those things, the only way they've been able to request or require you to do that, and the only way you've been legally allowed to do that under license law for years, is if they have signed on the dotted line of an exclusive right to buy and check the box agency at the top. That's it. So this concept of us giving away free fiduciary to anybody just because we've given somebody a brokerage disclosure to buyer and created a transaction brokerage relationship, A, I don't know why you'd ever do that, and B, it's a violation of license law. You're offering a brokerage, you're offering fiduciary duties that you haven't disclosed to all parties. And so anyhow, you've got to get better about that. But 7.3 is where we've always talked about 7.3.1, 0.2, and 0.3. And these have, and I'll just summarize. This is where it's always said: buyer's obligated to pay, seller may pay, buyer will pay, or buyer is not obligated to pay. So I'll start right here. I got to jump forward a bit, but guess what? 7.3. What I think was 3 is going away. There is no more in the exclusive right to buy listing agreement. There is no more option that your buyer is not obligated to pay. It's gone. It's been removed. The only two possibilities that your buyer has as they're engaging you as their broker through an exclusive right to buy in Colorado are either 7.3.1 seller's brokerage firm, seller's brokerage firm or seller may pay, buyer is obligated to pay. Buyer's still obligated to pay. Brokers authorized and instructed to request payment of brokerage firm success fee from one or both of the following, either the seller's brokerage firm, listing brokerage firm, or the seller. Buyer is obligated to pay any portion of the success fee that you've negotiated above here in paragraph 7.1.1.1. Any portion of that, buyer is still obligated to pay, which is not paid by seller's brokerage firm or by the seller, but only if broker discloses to buyer the amount buyer must pay in writing and prior to buyer entering into a contract with the seller. Okay? So your buyer is on the hook either way in either of these two scenarios, and the buyer will pay. The next one, and I'll come back to explain the other. Buyer will pay is the only other option, and that means that you're not to go out and request compensation from the seller or listing broker. In other words, the buyer's agreeing up front, hey, whatever we've agreed to in this success fee, that's it. I'm going to pay you, and this is our agreement and contract to do that, period. All right? So let me jump back up to 7.3.1 now and explain that last little caveat. So buyer's going to pay any portion that they may be obligated to. But this line 157 and 158, this is a great example of where, you know, you might see in paragraph 29 of the contract to buy and sell, that first thing we talked about, multiple boxes checked. So let's say that your buyer has agreed to your success fee is X in the paragraph 7.1.1 above. And through all your negotiations and requests to the seller or the listing brokerage firm, the most you're able to get the seller or listing brokerage firm to agree to pay you is X minus 7. All right. So you're still 7 of whatever short of X. Well, what that means is that 7. So you're going to you're going to put X minus 7 in seller to pay 29.1 or listing brokerage firm to pay 29.3. And then your buyer is going to have in their box 7, whatever that might be, right? That's going to be because they're 7 short in what you're collecting from X. So that 7's got to be in 29.2 that discloses to your buyer that they're obligated when they sign that contract. And if the seller accepts it, they're obligated then to pay you 7 in my example. See, this gets really tough to try and be very true to the spirit of not, fixing commissions, but I hope that makes sense. So point being that the contract then would satisfy that last sentence. So if you're checking the boxes correctly in paragraph 29, then you're going to review that contract with your buyer and say, hey, buyer, just look here. You owe me X. Seller, listing broker, whoever between them, they're only offering me X minus 7. That means that I'm checking the box 7 for you, buyer, and you're going to be obligated to pay me that at closing. And you're going to do that in reviewing the contract, and that's going to be your evidence there that you've disclosed that in writing to the buyer prior to them entering into a contract with seller. Now, you might follow that up with an email. You might try and reinforce that however you want, but it's important to do that your buyer's very clear what they're going to be coming out of pocket based on the contract that they're signing. So anyhow, that's that. And then 7.3.2, buyer will pay, buyer is obligated to pay brokers. I guess I already did that. So you guys get the point. Only 2 options now for buyers. Buyers are going to be on the hook. And there, of course, is the deletion of buyer is not obligated to pay. It no longer exists in the agreement. And because the buyer is going to be obligated to pay you either through this document or through the compensation section of the broker disclosure to buyer, that enables you to put it in the contract, ask the seller or listing brokerage firm to pay you, and or memorialize the buyer's obligations there. All right. 3 of the documents done. Document number 4, brokerage disclosure to buyer. So this is your good old brokerage disclosure to buyer. There's the definitions of working relationship that it starts with. Here's where you're disclosing the brokerage relationships. A little bit of cleanup here, nothing substantive. This is a situation where you're going to be, letting the buyer know, hey, we don't have any, well, two ways that you'd use this primarily. One is you're an agent or you're a TV for the seller, and you engage with a buyer you're in an open house for your client, sit in an open house of your own. Buyer comes in, you're going to give them the broker disclosure to buyer, say, hey, buyer, you're a customer right now. You're going to check box number one. I'm the seller's agent or I'm the seller's TV. You're a customer. I owe you nothing, right? That's how you traditionally use it. The other way this can be used, though, and it's, I think, far too commonly used this way, but nonetheless, is that third box, transaction brokerage only. What this has been saying to buyers for years, and this is how you've been able to establish a transaction brokerage relationship with your buyers without an agreement, without a writing. Again, this is only a disclosure. It says somewhere, I think on here, this is not an agreement. It always has. But the bottom line is you're checking transaction brokerage only. So if you're doing that, then I don't know if it says, it does say somewhere on there. If you're doing that and you're going to start working with a buyer without an exclusive right to buy, means they owe you no exclusivity, they owe you nothing. But you do have to have a written agreement. That's not state law. Remember, that's going to be your MLS participation rules. Then you're going to have to address part 2 of what is the new broker disclosure to buyer. And that's all this read for 2 pages of it. Or, well, it's 1 page, but in my slides here, it's essentially 2 pages. All right, so let's talk about this buyer broker's compensation agreement. Now, notice the word up here, agreement. This is, when they sign this is an agreement. And their signature of this will satisfy any touring expectations or touring agreements that your MLS rules are supposed to be imposing on you. So this is the solution to the touring agreement. Again, not any third-party touring agreements that you've seen floating around on the interwebs or anything else. This is what you should be using to satisfy a written agreement with your buyer prior to touring properties. All right? Compensate, unless you've got an exclusive right to buy with them. If you've got an exclusive right to buy, you don't need this, obviously. But if you don't have an exclusive right to buy, if you're going to default to a TB, you need to do this second part. Compensation charged by brokerage firms is not set by law and fully negotiable. We've heard that before on the other 2 documents. And they even made it in big caps to make sure that everybody's clear. In consideration of the services to be performed by buyer's broker as buyer's transaction broker, buyer's broker's brokerage firm, the brokerage firm, will be paid a fee equal to blank % of the purchase price or blank dollars, success fee, with no discount or allowance made for any efforts by buyer or any other person, unless approved by buyer in writing. Brokerage firm is not entitled to receive additional compensation, bonuses, incentives paid by the listing brokerage firm or seller. That looks awfully familiar to the exclusive right to buy. So does the next one. Well, so does most of this, because it's really trying to replicate the same concept. The success fee is earned by brokerage firm upon buyers, brokers performing services that result in buyer entering into a contract to purchase property acceptable to buyer and is payable upon the closing of the transaction. Remember, commissions are earned at the time of contract. They're paid at the time of closing. If any transaction fails to close as a result of seller's default with no fault on the part of the buyer, the success fee will be waived. In other words, if your buyer does nothing wrong, seller says, I'm not going to perform. Buyer says, that's fine. I'm not going to sue you for specific performance. We're just going to let it go. I'm tired of fighting over this. Then the buyer's not going to owe you anything at that point. And that's really, in my view, mostly how it's been. But if any transaction fails to close as a result of buyer's default in whole or in part, the success fee will not be waived. Such fee is due and payable upon buyer's default, but not later than the date the closing of the transaction was to have occurred. What does that say? If your buyer's the one that says, hey, I'm going to default. I'm not going to deliver earnest money. I'm not going to perform. And they default on their contract, then they would still owe you, pursuant to this agreement, a success fee. Because remember, you earned your success fee at the time of putting them under contract. All right. Broker is authorized and instructed to request payment of success fee from one or both of the following: the seller's brokerage firm or the seller. Buyer is obligated to pay any portion of the success fee which is not paid by seller's brokerage firm or seller, but only if broker discloses the buyer to the buyer the amount buyer must pay in writing and prior to buyer entering into a contract with the seller. Very same language, or basically identical language from the exclusive right to buy that we just talked about. And folks, this is going to be what satisfies a touring agreement. And it's important, again, regardless of, whatever the imposition of a written touring agreement and the validity of that requirement in Colorado, wherever that ends up maybe being settled, if you're not getting this completed with a dollar or I should say a percentage amount here or a dollar amount there, then you're working for free, because you literally can't ask the seller or listing broker to pay you anything beyond zero, because that's all you're entitled to receive from your buyer. And that's the real rub with this, is written agreements are fundamentally important, more important than ever. Now, here's the signature block, not a lot to talk about here, but this is what makes it, an agreement. The buyer's not just acknowledging their receipt of a disclosure like they are in the top section, which is the broker disclosure to buyer, not an agreement. This is they're agreeing to all of those terms with you. You're executing it, they're executing it, and that's a contract. So that's the broker disclosure to buyer. The fourth out of 5 documents that we're going to talk about, and that was the last document that is a Colorado Real Estate Commission approved form. So, and I'll come back to questions. I'm scared to look in the Q&A box, but anyhow, somebody will babysit me, I'm sure, with that. All right, let me address the 5th form that you're getting. And let me give you some background here. So let's look at the preamble to that document, to this brokerage firm compensation agreement. So this is going to be what you would use if you're expecting, this is what you're going to use in lieu of the offer to compensate that you have been able to rely on in the MLS for generations. I don't care how long you've been in the business, for your entire brokerage career, you've been able to rely on that offer of compensation that the listing brokerage firm, the seller's agent or broker, is going to pay you, the buyer broker, at closing, whatever the percentage that was listed in the offer of compensation. This is what you need in place of that now, if you expect that the listing brokerage firm is going to have any obligation to compensation. So when the forms all started getting discussed for revisions based on the practice changes, the Division of Real Estate essentially declined to promulgate a commission-approved brokerage firm compensation agreement. It's not an agreement between a consumer. It's not an agreement between 2 consumers, like a contract to buy and sell. It's not an agreement between a consumer and a licensee. This is an agreement between brokerage firm A and brokerage firm B, listing brokerage firm and buyer's brokerage firm, right? And so they didn't promulgate one. Well, the good news is that we had a solution for this. And about 5 or 6 years ago, Colorado statute was changed, and you guys, CAR, our government affairs folks, and your initiatives had the fortuity to work on some of this without any anticipation of needing it. But essentially, there is now a standard form category that is available. So standard forms in Colorado, most common commission approved form, an attorney prepared form, a client prepared form. One of the other categories that was added about 5, maybe 6 years ago now was a form prepared by the Colorado Bar Association and authorized for use by Colorado real estate licensees. All right, and that's what this is. So this form from the Bar Association is as good as a commission-approved form. It can be used in the same way that you would use any commission-approved form because it's stamped in that way. I want to say a couple of things. First of all, the Bar Association and Real Estate Section Council, that's the division of the Bar Association that is primarily composed of real estate lawyers. They have been incredibly supportive over the last several years on a number of things since that legislation change enabling them to promulgate statutes. And so I got to salute Real Estate Section Council for their collaboration with us, the realtors, on a lot of things. But these forms are imperative. And you guys know Damian Cox, he's the liaison from the Real Estate Section Council to the Realtor Association. And he's been a fantastic advocate been very easy and nice to work with him in getting some important things done. So kudos to them. I know everybody wants to say, oh, we don't like the lawyers, but over the last few years, this relationship has gotten very valuable and helpful, I think, to both parties. So thanks to Real Estate Section Council and the Colorado Bar Association for stepping up and filling a void that was going to be left if we didn't have this document. They did this about 4 years ago. If you remember COVID, there was the COVID addendum. And I think CAR requested on a Thursday a COVID addendum to attach to a contract during the intense COVID days where we didn't know if title company offices were going to be open to close things or if lenders could underwrite or whatever. We requested a COVID addendum on a Thursday, and by I think Monday or Tuesday of the very next week, we had a COVID addendum that was used broadly throughout the state. They did a rate-on disclosure for landlord-tenant relationships last year. So this is the third one that they've used. Brokerage firm compensation agreement, not been approved by the Colorado Real Estate Commission. This agreement has been issued and approved by the Colorado Bar Association for use by Colorado real estate licensees pursuant to the statute there. And so that's the important stamp that this document needs to enable you to use it exactly as you would any other commission approved form. So here's the top part of it. It's going to set up the parties. It is the date of the agreement, seller broker, seller brokerage firm, buyer brokerage firm, and the property address. What is not listed here are the parties. So the property address is what's going to tie this whole thing together. But the buyer is not listed. And the thing is, we started talking about when we started drafting this form was the fact that a lot of buyer brokers, you need to get this thing out on the table early, like I would say in connection with showing the property, or as early as you can, you need to get one of these things in your file so that you know that your efforts will be compensated. But a lot of buyer brokers weren't going to want to put their buyer's name into some agreement before they even showed the property, or before they wrote an offer, or before they did anything. And so we had to kind of do it this way to leave it a little bit more ambiguous. But then if we left it that way, then I could see where listing brokers would be like, oh my God, how do I know who I'm going to be committing to? And maybe some buyers talking to 2 or 3 or 5 different brokers, and maybe I'm signing this for the same buyer. I can't see the buyer's name, so how do I know who I'm committing myself to? So we had to address that in the substance of the agreement, which was kind of a unique little twist. But anyhow, let me go through this very quickly. Seller brokerage firm. So this is an agreement. The ultimate agreement is between the seller's brokerage firm, the listing brokerage firm, and the buyer's brokerage firm. It's between the brokerage firms, not between the individual brokers. All right. Very important point to remember. Commissions, compensation is paid between brokerage firms, not between individual brokers. So seller's brokerage firm and buyer brokerage firm are parties to this brokerage firm compensation agreement. Seller brokerage firm represents that it is actively engaged in an exclusive right to sell listing agreement, a listing agreement with the seller of the property, and seller broker is designated to perform brokerage services on behalf of brokerage firm to seller. Buyer brokerage firm represents that buyer is actively engaged in a brokerage relationship with a buyer, or buyer's successors or assigns interested in purchasing a property similar to the property. Buyer broker is designated to perform brokerage services on behalf of buyer brokerage firm to buyer. Now, that's that third paragraph there, the buyer brokerage firm representation. You got to have a brokerage relationship, and that, remember, is either going to be an exclusive right to buy, checking the box agent or TV at the very top, or it's going to be a broker disclosure to buyer defaulting to TB, but also having that compensation agreement that is executed with your buyer. All right, now the second half, and this is where we get kind of into the meat of everything. The parties agree that upon buyer and seller entering into a contract for the purchase and sale of the property, the real estate contract, and successful closing of the sale of the property, which is the closing, to said buyer, seller brokerage firm agrees to pay buyer brokerage firm compensation in the amount of blank % of the final purchase price as described in the contract, or blank dollars, the flat rate. So those 2 boxes align directly with the exclusive right to buy, exclusive right to sell, and the broker compensation agreement in terms of those in terms of how those set up. However, buyer broker must, and this is an important thing to be critical or to be very clear on, buyer broker must tender the real estate contract, and buyer brokerage firm must continue to work with buyer through closing. So in order to be eligible for this payment, you have to be the buyer broker who tendered, wrote the offer, and presented it to the listing broker or to the listing brokerage firm. And you've got to be the same broker who actually carries out all the brokerage duties and closes the transaction. So that's the line, though, that gives listing brokers the ability to say, you know what, I'm fine signing a number of these with different brokers, even if I don't exactly know who their individual buyers are out there, because I know that the only thing I'm agreeing to is compensating based on the dollar or percentage here. The only thing I'm agreeing to is compensating that broker who actually writes the offer and gives it to me, presents the offer to me and my seller, and who is the broker who follows through and is the broker essentially closing or acknowledged at the closing as the closing broker. And there's only going to be one of those, right? There's not like somebody who said, oh, you signed this compensation agreement, but I was working with that buyer earlier. So this concept of procuring cause, as many of you heard me say, is gone, essentially. I mean, that's just not how it's working anymore without the offer of compensation in the MLS. So anyhow, for listing brokers, you can be comfortable signing these things multiply without knowing exactly the name of the buyer, because you know that at the end of the day, there's going to be one broker or brokerage firm sitting across the table from you at closing, and that's who's going to be the commission. Is if that's the same one that's tendered or written and presented the offer and represented the buyer throughout the transaction, then that's who you owe that money to based on this agreement. So such compensation is earned at the time the real estate contract is signed, but is contingent upon closing, and buyer brokerage firm will be paid by seller brokerage firm at closing. Parties agree to the disclosure of such compensation in the real estate contract and or to their respective clients. So that's what gives you the ability to disclose all of this in most cases, it's going to be in the contract itself, because remember, this would be then where you're checking, I think it's paragraph 29.3. And if you have this in place, this is the separate agreement that you need in place to memorialize compensation from the listing brokerage firm. This is another important part for listing brokers. This agreement expires upon the expiration of the seller brokerage firm's listing agreement, originally naming the seller broker as the designated broker and any extensions thereof or additional rights thereon. So that would be referring to amend extends, extending the agreement, or any holdover period would be an example of additional rights. But be clear here, it is the seller broker. So let's say that the same brokerage firm, you've got the designated broker on this compensation agreement. And then let's say that broker leaves the brokerage firm, and the brokerage firm redesignates another listing broker to sell the property. Well, this agreement, if the old broker who left the firm had signed this, then this agreement is no longer valid. So you're going to need to be, if you're a buyer broker and you've received one of these things and you're relying on it, even though the agreement is technically between the brokerage firms, if the actual agent or individual broker, designated broker that you've been dealing with, it leaves, or if their agreement changes or expires, then you can't rely on this anymore. So it's not a perfect world, and this is reflective of how the MLS used to be. When you had, if a broker had an active listing, then they had an ability to have that active listing placed on the MLS, and the offer of compensation you could unilaterally rely on. But if that listing agreement was inactivated or had expired, then the MLS would have reflected that, and the agreement would have not been valid anymore. So it's trying to replicate the same concept there for listing brokers. Anyhow, the parties authorize their respective brokers to execute this agreement on their behalf. And that's the exact same language that comes out of the exclusive right to buy and exclusive right to sell, which are also between brokerage firm and consumer, not between the individual broker and the consumer, but you have the authority to sign the agreement on behalf of your brokerage firm because of that. And then, of course, the bottom is it's got the copyright disclaimer. So this agreement is available. It's up on the Bar Association's website. It's going to be in our linked resources page, and you'll see that here at the end. So we'll get there in just a second. It is $39. It's a fillable PDF. You buy it one time. Your brokerage firm buys it one time. They can use it as many times, thousands and thousands of times. So I know, commission doesn't charge for forms. The Bar Association, for intellectual property purposes, and they're not a government entity like the commission is, so they need to charge for the form. It's a one-time thing. It's honestly the best investment I think you can make in your business, to have a good compensation agreement. I can't emphasize enough, in my view, the importance of trying to use that form. If everybody's using a standardized form, then I think it makes it easy for listing brokers to know what they're getting into. It makes it easy for buyer brokers to know what they're getting into. And if we're starting to use throughout the state different forms that are prepared by maybe different law firms, or you're trying to use other things, I think it's going to lead to some problems. So I would strongly encourage your brokerage firms to purchase that form. I think the Bar Association probably is open to licensing that form to maybe MLSs and software providers. So inquire about that if you're thinking about doing it. But it is in all respects something that costs less than pennies per use. Once you download it, it's a fillable PDF. You can use it a gazillion times if you'd like to. So, all right. Where's my questions at? I don't see my chat box. Well, let me get to, wait, there's the resources. So there's if you go to that page right there, let me just hit that real quick, coloradorealtors.com/2024 changes. That will take you to a resource page. We're actively building that. We just kind of started it in connection with this. That will get you to a lot of N.A.R. resources. If you've looked at N.A.R.'s facts.realtor website, you could spend 5 days going through information there about the settlement agreement, the MLS changes, everything else. There's also a link right there to get you to the Bar Association's website to purchase that form. There's a link to all of the red lines that I'd mentioned earlier on the division's website. And we're going to just try and keep updating. We'll put the YouTube video link to this session on that website. So we're going to try and just keep building that. We did one of these kind of in COVID, and it was pretty successful in trying to aggregate information for you guys into one place. coloradorealtors.com/2024 changes. You guys know Legal Bites. Hopefully you use those. And all right, let me stop my share here.
Hey, Scott.
And my yeah.
So your Q&A box will be bananas crazy. We have very hungry members that want information, but I have set it up so if you just scroll to the top of your Q&A box, we have it set up to where the most upvotes are going to be at the top of your Q&A box.
Perfect. Yeah, that's very helpful. Thank you, Holly. And I want to just acknowledge our staff here. They've been scrambling. You see these faces around. These guys have really scrambled to try and put something together here, and just in terms of supporting realtors around the state and being responsive to this incredibly kind of watershed moment in our industry. So well done, everybody at CAR. And Jason, thanks for being a great leader in this time. All right, let's see. Can we begin using the brokerage firm compensation agreement released by the Colorado Bar Association? Thank you. Yes, you can. Yes, you can. It's available. That doesn't have, unlike the commission approved forms, which is the first 4 forms I talked about, those you cannot use until they become mandatory. And then from August 15th, which is when the mandatory date is, you have to use them. Bar Association form, you don't technically have to use because it's not a commission approved form, but I would strongly encourage our industry to use that document. I think it's going to be the very best solution to a lot of these issues. Yes, you could start using it immediately. The only little bit of a wrinkle is if you're a listing broker, you want to be clear that you're not, that whatever, because for listing brokers, you're still going to have an offer of compensation that's embedded in your MLS. And so what you don't want is for you to somehow have somebody believe that you're creating supplemental obligations to compensate a buyer broker. But yes, the form is available and you can certainly use it. How do we know a listing agent doesn't have in their listing agreement that the commission shall be X, but if I can get the buyer to pay part of the commission, it'll be the lower of X? Well, I suppose it's the same way as it is now, and it has been. I mean, if a listing broker might have their exclusive right to sell listing agreement and it might say X, but what they put in the MLS might be something less than X. Same answer in both cases. If a listing broker, if you're inquiring of a listing broker, or a listing broker is advertising on their brokerage firm websites or any other place what their compensation being offered, that number better be consistent with what they've already agreed to with their seller. And so if they're doing anything differently than that or playing any games, they're in breach of their exclusive right to sell listing agreement. They're in breach of their fiduciary duties, uniform duties. I mean, that's a mess. And so I see the concern, but I'm hopeful that the listing broker and brokerage firms and through education and everything else understands that you can't unilaterally be making decisions about what you're going to do in terms of offering compensation that's anything inconsistent, even by a penny, from what you've agreed to with your seller through your listing agreement. I have a listing agreement expiring on August 4th. Can I do an amend extend for an extension, or do I have to do a new contract? No, I mean, August 4th, you're not going to have anything available of the commission approved. So you're going to do an amend. You can just do an amend extend it out. And I'm assuming by listing agreement, you mean listing sales agreement or for sale. I think that's fine. I don't think there's a need to amend that unless the compensation is changing. Let me make a really important point here. Because everybody's probably fallen asleep listening to me drone on, but I kind of forgot to address this in the exclusive right to buy, but I want to be clear here. The one thing is, if you have an exclusive right to buy that's currently active and it's going to go through August 15th, I don't think you need to amend it except for a situation where you have checked in your current exclusive right to buy, buyer is not obligated to pay. Remember, guys, that box is going away after August 15th. So if your buyer is not obligated to pay you on August 15th or August 17th or September 50th, 15th, on September 15th or whatever point later down the road, what I mean is you can't take anything. So you're going to have to amend your exclusive rights to buy if one of two things are present in the current one. If it either says, if you've either checked the box that says buyer is not obligated to pay, which a lot of you do, or if you've checked the box buyer, or I should say no, or if your success fee in your buyer agreement is a range, or if it's not, the language from the settlement agreement refers to objectively ascertainable numbers. And so if your success fee in your existing exclusive right to buy has a range, and it says between X% and Y%, or not less than Y%, or anything that is not an objectively ascertainable hard percentage that can be just everybody knows what it means, then yes, you're going to have to do an amend extend to your exclusive right to buy to change those. And either use the new contract, you can either terminate your old one and use the new one, or you could do an amend extend to the existing brokerage agreement and change it to check the box. Buyer is obligated to pay, seller may pay, or seller or listing brokerage firm may pay, at any range that might exist there. There can't be any ranges. So if that's what you're living under right now, then you are going to need to amend that contract. I do have a question. Does this affect current listings not under contract yet? Same answer. I think I've answered that, I hope, pretty clearly. If you have to amend your exclusive right to buy because of whatever I just described was present, either TBD or buyer is not obligated to pay or some range, then you're going to have to amend it after August 15th, because you can't accept anything more than what the buyer is hard and fast obligated to pay you. Or if your seller wants to change the compensation being offered, decrease it, increase it, change something, you're going to have to amend it. Otherwise, you can use it. Can you clarify whether or not listing agents will be allowed to ask for a buyer's agent agreement? I was on another webinar where I heard they say they will not be required. Yeah, I mean, the buyer's agent agreement is between the buyer and the buyer's broker. That is a confidential document that they shouldn't be sharing with third parties and requesting copies of it. But be clear, it's kind of a derivative of the answer I just gave with regard to the first question, which is how do we know what the seller's agreement is with the listing broker in terms of, is it consistent with what they're offering to pay me? If you're a buyer broker and your buyer has not agreed to compensate you through some agreement, then you're not allowed to accept any compensation. And it would be that would be a violation of state law. If your buyer has said that your success fee is zero in either the compensation agreement or in the exclusive right to buy, and you're going out and asking for compensation more than zero, then that would be a breach of that agreement. You've got an inconsistency, because remember that now that exclusive right to buy says that you're not allowed to take anything more, period. So now you've got a breach of your agreement. So just like listing brokers need to be aware, they can't be making unilateral changes to an agreement that they've made with their seller about what they're offering to a buyer broker. If you're a buyer broker and you're asking for compensation that you're not entitled to because you don't have an agreement with your buyer broker, then you're in breach of your fiduciary as well. So, the market's going to have to ferret some of this out. I can promise you the Division of Real Estate is going to be standing ready to discipline anybody who's breaching their either fiduciary duty, uniform duties, their general contract or their general exclusive right agreements. That's all what that regulatory body will do. In terms of any of these MLS rules, then as I said from the very jump, the shenanigans or perceived shenanigans by your MLS, they're going to be enforcing those rules. So I'm not sure what else I can say about that. I get the concern, but I'm hoping that people are aware enough that they're risking license discipline and MLS discipline if they're playing around in that particular realm. If I have a seller who at the time of listing is adamant they will only pay their listing broker, but as we all know, people change their mind, can I fill the agreement with X% for listing broker? And then the additional provisions say if seller decides to pay listing brokerage fee based on offer, then total commission owed at the time of closing will be X plus Y. Yeah, I mean, I think that's fine. Sure. I mean, I think if your seller's telling you they don't want to pay compensation, then I think that's where you're probably advertising that your seller's not offering compensation, but is willing to consider it. And so the buyer broker is going to have to put it in the offer. And remember, in that case, it's going to go in paragraph 29 and it's going to go in paragraph 29.1, which is going to be seller agrees to pay. and that's going to be the security for the buyer broker's agreement. And so, you know, I think that's probably the best way to do it, but I don't think there's anything, Ann, wrong with your clause there as it's written. If there are any MLS systems that are not affiliated with N.A.R, will offers of compensation be allowed? Not in Colorado. It's not a matter of an affiliation with N.A.R. I'll say in Colorado, there's only one non-realtor owned MLS in the state. It's down in kind of south central Colorado, Spanish Peaks area. And I do know, as a matter of fact, that they elected to opt into the settlement agreement. They had to sign a different opt-in agreement than the realtor-owned MLSs, but they had to opt into that agreement. And so I'm not aware in Colorado of any brokerage firm, or I'm sorry, excuse me, any MLSs that have not opted into the agreement, which means that whether they're realtor-owned or non-realtor owned, whether their participants are realtors or anybody or everybody, the MLS is bound by the terms of the settlement agreement, which includes everything that we're talking about in that case. And also, just to say it, because I know it's people are asking about it, you know, to the extent that a MLS is being sold to a non-realtor entity, it's my understanding, and I can't imagine that there's any intent to change any of that. But moreover, remember the MLS, the existing entity signed an agreement saying that they're going to be bound. They opted into that agreement. And so somebody just buying that entity doesn't give the buyers the ability to say, okay, agreement doesn't apply to us anymore. Because, you know, when you acquire an entity, you are bound by the agreements and obligations and rights and responsibilities that they had pre-existing your ownership of it. So I don't anticipate anywhere in Colorado that will be the case. Can you advertise a commission / amount for bonus? You can't advertise. You can advertise it anywhere you want except the MLS. If you are putting anything even potentially related to commissions, compensation, bonuses, seller concessions for buyer's broker, anything about that in your MLS, you can count on the fact that your MLS will be very quickly responding to that nomenclature and either delisting your property or sending you some sort of a warning letter and turning off those comments. So no, you want to put it on the yard sign? Have at it. You want to put it on your brokerage firm website? Have at it. But remember this for buyer brokers. Let's say that you've got a brokerage firm and they have all of their listings on their own website, and they have some little star or something that says X% compensation offered or cooperation offered or whatever. That is not like the old MLS. That is not an offer, but I guess it technically would be an offer of compensation, but that offer of compensation on, you know, whatever brokerage firm website, that isn't bound by the same agreement, the MLS agreements, that the conventional offer of compensation is. So while that is them telling you, hey, we will pay compensation, you need to accept that offer and memorialize it through some form of contract, which is going to be that brokerage firm compensation agreement. So don't just look at somebody's brokerage firm website that says, oh, we're offering X% for anybody who brings us a buyer, and go, okay, I'm covered. That's not enough. It was enough in the offer of compensation on the MLS. It is not enough going forward, because the MLS had rules that made that offer of compensation unilateral and enforceable in and of itself. Sign writer, yes, fine. Can property-specific website display an offer of compensation if the link to that website is attached to the MLS listing? I mean, you're going to have to talk to your MLS, but I'm going to say their answer is probably going to be no. I mean, how the MLS interprets some of these more, I don't know, tangential kind of questions is ultimately going to kind of be up to the MLSs. My guess is they're going to be very, very, very conservative with regard to anything that is fed from the MLS directly through a link to your brokerage firm website that offers it. In fact, I think even the settlement agreement precludes anything fed by the MLS. So my answer to that is going to be no. But you know, some of this is going to have to evolve over time. I'm being solicited by My Colorado site, apparently offering a workaround and not subject to the rules. So good question. I've seen a lot of these things. I'm not going to kill anybody's business model. What the settlement agreement speaks to is the offer is the MLSs and offers of compensation on the MLS. These third-party websites where you can aggregate commissions, to me, they seem like nothing more than a great big old opportunity to put a target on their back for another collusion, collaboration. They're essentially acting as an MLS, doing the only thing the MLS has been adjudicated to not be able to do, and that's all they're doing in these cases. If I speak to my policy, if I was an employing broker, managing broker, my answer would be absolutely not. We're not going to play games there. Maybe something will evolve. Maybe more guidance will come. Maybe, maybe things will change, but I'm going to play this very straight. If I've got a brokerage firm of my own, I'm going to invest in doing what I need to do to help my agents facilitate their offers of compensation on our website or in other ways, and not in some other aggregator site or service. To me, it feels like it's just another exposure waiting to happen. At this point, at some point, can you address if MLSs are going to post list commissions paid after? It's my understanding that the vast majority, if not all of them, are not going to be doing historical commissions. As I understand it, again, we have 13 or 14 MLSs in the state. I've lost count a little bit, but the bottom line is they are taking a conservative approach to this, and I think that's the appropriate thing to do. Because remember, if they allow you to violate the settlement agreement that they've entered into, or if they themselves violate that settlement agreement that they've entered into, they're re-exposing themselves to all of this liability, and nobody's going to want to do that. So as I understand it, certainly among all of the large MLSs in the state, and I'm guessing everybody, that on August 15th or whatever date they flip that switch, any references to compensation, historical, current, going forward, for historical, compensation is gone from the MLS. And so if they have a different policy, then that's up to them, between them and their attorney, to interpret that. How does the division director's letter to N.A.R. stating it violates revised statute affect how we utilize a buyer agreement? Guys, this is my challenge here. I listen to your regulator, right? But that kind of screws over MLSs, because I think the MLSs are largely being told by N.A.R. you have to abide by this. And so I can tell you this, I am actively engaged in conversations with N.A.R. to try and have a solution that works for everybody. I'm becoming exhausted, frankly, by those conversations. But you do not want to do anything that's in violation of license law. And so I could spend an hour getting into the weeds on this concept of this inconsistent with. N.A.R. has one perspective, regulator has a little bit different perspective. And so I guess what I would tell you is this: regardless of where all that shakes out, as I've emphasized previously, and I'll re-emphasize now, it is critical that you obtain, as a buyer broker, a written agreement that memorializes your compensation with your buyer, because if you don't have that, you are allowed zero, nothing more, period. Can we put in agent remarks MLS more information on home? Please see my website. That's a question for your MLS. I'm guessing that's probably fine. But if they find that that is really just coding for, here's a link to my website with my commission, they probably won't think it's fine. Can I change my Zillow and Realtor profile to say that I offer X compensation on my listings to buyer agents? I'd be careful about saying I offer X to all of them. Commissions are independently negotiated. And so commissions between a list, even the same listing broker, and 25 different sellers, really, I would argue, ought to be manifesting in potentially 25 or at least a handful of different levels of compensation. To the extent that you're a listing broker and you tell every seller, like, I will not work with you, I will not execute this exclusive right to sell listing contract with you unless you're offering X for compensation, that's your prerogative. But I think that's a pretty hard line to be taking. I'm not saying you've got liability for that, because you're a party to that contract. You have a right to freely negotiate it as aggressively or not as you care to. So that's a conversation in terms of with your seller. So does the ruling apply to commercial and business brokerage? The ruling applies to MLS rules. That is how, as I said from the beginning, that's how all of these practice changes are being imposed. Not from N.A.R., not from C.A.R., not from your local association, not just on realtors. They're being imposed on MLSs that have opted into the settlement agreement through the MLS rules. All right. And so commercial and business brokerage typically aren't on MLS. I guess it doesn't apply to them. Is it a violation to allow customer to view an MLS auto email without written agreement in place? I don't think so. I don't think that's a violation of the MLS rule. You're not touring them. You're just giving them property information. I think the touring agreement is meant before you put them in the car and you start driving them around and showing them different properties. And remember, it's an MLS requirement, not a state license requirement. Would a buyer agreement also apply to hosting open houses? If so, how to propose to execute one in practice? I mean, if you're hosting open houses, I don't know exactly what you're doing. If you're hosting open houses and you're the listing broker, then you need to be using the broker disclosure to buyer to explain to an unrepresented buyer who comes in the front door that you're the seller's agent or the seller's TB, and you're disclosing that relationship. If you're touring them around your own listing, I don't think at all, because that's your listing. If you're sitting open houses trying to generate business for yourself, I think you've got to really ask yourself, what's your brokerage relationship and who's it to? So I don't know if you're sitting in an open house on behalf of your brokerage firm or another broker in your brokerage firm, and you're going to show them your brokerage firm's listing. I'd say, to me, that feels okay. But if you're going to be taking them around to any other properties as a result of that engagement, then at least in your MLS rules, that would require a written touring agreement. And that's going to be your broker disclosure to buyer with the compensation agreement attached to it. Could a buyer have this new buyer agreement sign multiple agents, or is it exclusive? The buyer, the exclusive right to buy is exclusive, as it always has been. The broker disclosure to buyer with the compensation agreement, that is not exclusive. There's no, it's like it's just the disclosure. But remember, the buyer owes you nothing in that case. They have the compensation agreement that I suppose if a buyer is signing multiples of those for brokers related to the same property, then yeah, buyer could be creating multiple exposure points to multiple brokers. And so I think and this is all part of that same discussion that you should have been having for a long time anyhow, which is, hey, buyer, are you engaged with anybody else in any other brokerage relationships? Are you engaged in any other written agreements with any other brokers before you're obligating a buyer to you? Because then you get into potentially sign crossing, although, well, you can get into potential sign crossing issues, at least if they have an exclusive right to buy. What if we don't use the MLS to schedule a showing? I don't think it, I mean, I don't know how to answer that question. I mean, sure. All of this is, you're going to have to decide what your tolerance and comfort level is with everything and kind of proceed from that. Who will be auditing and making sure the buyer agent has obtained buyer touring agreement prior to showing? This is MLS rule. So to the extent that there are violations or alleged violations, you would be complaining to your MLS. They're the only people that would be investigating the buyer touring agreement or lack thereof. They're the only people that are imposing that rule on their participants. And so that's going to be where the enforcement of that lies. If you go to the Division of Real Estate, you're going to get a letter back pretty quickly that says, not our problem, we don't care. And so be clear on that. Is the written agreement type tying the buyer to the agent, like buyer's agency agreement, or disclosing duties and commission? It depends on what you're getting. If you're using the exclusive right to buy agreement, that is your written agreement, your touring agreement, it's everything for you. And that's the best place you can be every time. I can't emphasize that enough, because it's exclusive. So that would be what ties you to the buyer. If you're using the broker disclosure to buyer and the compensation agreement to form the basis for your touring agreement, then it's that document that ties you to the buyer, or ties the buyer to you and that compensation. So seller can pay, but needs to be in buyer's agreement. Seller can pay. The easiest way to say this is that the buyer's broker can only accept what is an amount up to what the buyer is obligated to pay them through the buyer's agreement. So if the seller is going to pay, remember, that's not going to be in the buyer's agreement. That's going to be in the contract to buy and sell, paragraph 29, specifically 29.1, saying that seller agrees to pay buyer X. That's where that's going to be if the seller is paying. How do we cover open house visits? Is there additional provision language we need to add that conveys? So is there an additional provision language that we need to, I mean, open house, here's the deal. This all goes away if you get an exclusive right to buy with your buyer. Your buyer can go out and look at open houses all the time. Your buyer is obligated to pay you your buyer is breaching. If they're going to try to put a house under contract, if they're negotiating for a property outside of you, they are in breach of your exclusive right to buy, meaning you have a breach of contract leverage and potential cause of action against your buyer for not acting exclusively with you. Another reason, get your exclusive rights to buy executed with your buyers, and then you don't have to worry about if they're out looking at open houses. Now, you should be reminding your buyers in either case, hey, you're working with me, particularly the exclusive right to buy, you're working with me, you'll be in breach of this agreement if you're going out and negotiating for other properties. You want to go look at open houses, have at it. That's on you. But If you're writing contracts without me or writing contracts with another broker, that's an independent breach of our exclusive right to buy. The broker disclosure to buyer, again, there's no exclusivity. So the buyer owes you nothing. They never have. And so I don't, I'll give you some thoughts as I close my thing up about this. But you guys, I've been saying this for a long time. You guys work too damn hard and are too damn valuable to the real estate transaction process to work for free. And I have had for years on the legal hotline calls from buyer brokers who I am terribly empathetic to. And they say, oh, my buyer, I've been running this buyer around for the last 4 months. I've shown him 25 properties. I've written 4 offers. None of them got accepted. And I just found out that they went under contract with another broker. What do I do? And my answer is you don't do anything, because you haven't done anything, because you never got exclusivity. At least if they had an exclusive right to buy, you'd have some leverage. You'd have leverage with your buyer. You might have a sign crossing issue with the other broker who's working with them. You've got an ability to recover for your hard work. But we have a tendency, and for too long have just not given ourselves as an industry the respect that we deserve for the hard work that we perform, particularly on behalf of buyers. And it is 100% uncompensated unless your buyer is successful. It's called a success fee, because the only way that you're entitled to it is if you're successful. So somehow we've got to get to a place where we're not worrying about what happens if we don't have exclusive agreements, and we get there by getting exclusive agreements. So you're saying that even if seller offers compensation, if we do not have a written agreement with the buyer, we cannot collect that compensation offered by the seller. That's what I'm saying. Correct. That's what the contracts say. That's what the settlement agreement says. That's everything. That now says that if your buyer is not obligated to compensate you, you can't take compensation. Can we accept more from the seller than we have agreed to in our buyer agency? The answer is no. You can only accept up to the amount. I'm sure you could accept less, but you can't accept more. And the agreements now all say that. Can you confirm if you check the box buyer is not obligated to pay, then you cannot collect the commission? Remember, buyer is not obligated to pay on August 15th, 2024, in 3 weeks, whatever that is going away. That is no longer a field that your buyer can check. It is only going to be buyers obligated to pay, or buyers obligated to pay, seller or listing brokerage firm may pay. That's it. So, so if you check it, and if you have an existing exclusive right to buy with a buyer that you're relying on in September to close on a property, and that box is checked, buyer is not obligated to pay, you cannot accept compensation. And I can't be more clear about it than that. So if you have clients under contract prior to a week ago, you don't need to revise anything. Again, no, unless you have to. If you got an exclusive right to sell listing agreement and the compensation is changing, then you're going to have to, if you're a listing broker, you got to amend that. If you got an exclusive right to buy and you're closing after August 15th and the practice change is going into place and you have the box checked, either TBD is your success fee, or buyer's not obligated to pay, or some range, you're going to need to amend that if you want to collect. Regarding buyer agent agreement, if you get an offer from an agent who is a realtor or a participant in this, but not in the MLS, regarding what if you get an offer from an agent who is a realtor and a participant in the MLS, but not in the MLS that they are putting the offer in for? It's now, I've said this for years, the only offer of compensation extends to only other participants of the same MLS that you are in. Well, now guess what? There's no offer of compensation regardless of whether you're in the MLS or out of the MLS. You need one of 3 things. You need it in the contract that the seller is going to pay you. You need a compensation agreement with the other brokerage firm, listing brokerage firm, who's going to pay you, or you need to have it, and you need to have it in your exclusive right to buy, whatever your buyer is paying you. And you can't collect anything more than what your buyer has agreed, even if it's from other parties. So yes, the thing is now that whole issue that I've preached about for years, that if you're taking a buyer outside of your MLS to go close a transaction, make sure you get some agreement. That's gone in its entirety, because even if you're closing a transaction in your own MLS, there is no commission obligation offered to you by anybody unless you have an agreement. Does this make a party to the realtor party to the contract? No. If the seller is agreeing to pay you through the contract, you are a third-party beneficiary to that contract. It does not make you a party to the contract. You are not a party to the buy-sell contract. But you would be in the case only if a seller is obligated to pay you. It makes you a third-party beneficiary. If the listing brokerage firm is obligated to pay you, remember, that's pursuant to a separate agreement. That's going to be the brokerage firm compensation agreement. If the buyer is obligated to pay you, that's pursuant to a separate agreement. That's the exclusive right to buy or the compensation agreement at the bottom of the broker disclosure to buyer. Division of real estate does not require paperwork before showings, but the MLS dictates, overrides what paperwork is required to show homes. Guys, it's an internal inherent conflict. I'm trying to resolve it in some way to get some clarity from N.A.R. I'm not getting a lot of traction with N.A.R. and the division seems pretty entrenched in their perspective. You're going to have to use your best judgment, but regardless of what the outcome is, get written agreements. I just can't emphasize that enough, because otherwise you're not getting paid. You're not allowed to collect anything. You may get into this. Will the MLS be asking for and publishing commission value? I don't think they're doing historical. You'll have to check with your individual MLS, but I don't think any MLS that I'm aware of is not going to have historical data. In section 29 for buyer broker compensation, can the seller and listing agreement request require a copy of the buyer broker? No, I would not be requesting or requiring that. Again, we're going to have to rely on the fact that if the buyer broker is asking for something that they're not entitled to, either a commission at all or any amount that's beyond what their buyer is required to pay them, they have a license law violation. They're in breach of their fiduciary, and they're also, in this case, in breach of their MLS rules. If we check the box 29.1, is the expectation that we fill in both the percent and no. It's only going to be the percent or dollar amount. Remember, commissions are not always percentages. Maybe it's a flat rate. Who knows? It's going to be either or in most cases. I don't imagine you would ever have both percentage and dollar. It's going to be either or. Where should we put that? Additional provisions, then it becomes a part of the contract. I'm not sure what that's in reference to. I'm sorry. But remember, for seller paying you, you are a third-party beneficiary, not a party to the contract, but a third-party beneficiary. The selling company still pays the buyer's company, not the buyer broker. Yes. I mean, if that's what's been agreed to, if there's a brokerage firm compensation agreement, that is the listing brokerage firm, seller's broker, paying the buyer's broker. Can we put your compensation offered by seller in the showing instructions? No. You guys, you're so creative. If you're putting anything related to compensation on the MLS, you are going to inspire the wrath of the MLS as quickly as any wrath you've ever inspired, including by your mother when you were an infant. It seems that what now happened is a broker comp will be a negotiating point. Yes, this is a reality of it too. I mean, I'm not excited about this, but there's going to be a time or times where, you know, the last paragraph, the only thing remaining between an executed contract by both parties and no contract is going to be paragraph 29. And guys, I wish I could give you a better answer than that, but you're going to have to be, this is your value as a buyer broker. You need to be having these conversations with your buyer. You need to be comfortable with articulating your value. You need to define what your value is. And you wouldn't be here, you know, over 3,500 of you, if you didn't have a value. You wouldn't show up for stuff like this. You wouldn't even be aware that this class was taking place. If you're in this Zoom room, then you have value. It's a matter of refining that value proposition and getting good at articulating, particularly to buyers. Think about it. Listing brokers have been doing this for a long time. You do a listing appointment. You go sit down with your sellers to get a listing executed, and you give them, you know, all your stuff. This is what we do. This is how we work. This is our marketing package. This is what we do. For buyer brokers, I think this is the wave of the future. You're going to be sitting down with your buyer saying, here's what I do, here's what I charge, and here's how we can make you not pay for that, depending on what box you're checking. So anyhow, I can't emphasize all of that enough. But yes, it's going to be a negotiating point, and you're going to have a strong relationship with your buyer and help them understand that they have already agreed to compensate you whatever the seller or listing broker is not going to compensate you. So maybe that's not the right property for them if that's what it's down to. And I hate to say it because I know not all buyers are going to respond well to that. If a buyer is required to check the box for 29.2, or is a buyer, if the buyer is paying their broker directly and disclose the amount, it seems odd that the buyer would be required to disclose the seller. Well, so if your buyer is paying you directly and you're willing to just completely rely on that, then remember that part of your listing agreement says that you have to disclose in writing to your buyer the new update to the listing agreement in paragraph 7 of the buyer exclusive right to buy, it says that you've got to disclose in writing whatever your buyer's compensation is. So I think 29 is the best place to do that. I suppose if you're going to send your buyer an intervening email that says, hey, buyer, here's your contract. We're not going to address my commission in the contract at all, but please be clear, when at closing, you're going to be obligated to pay me X, which is my success fee, and reiterate that in some other writing. I would, at a minimum, do that. Yeah, so I don't think you need to just disclose for the purposes of disclosing to the seller or the listing broker that, but it is a good place to do it so that you comply with the other terms of the settlement agreement, and more importantly to me, the terms of the exclusive right to buy as it's been modified now in paragraph 7. Is it true that in order to get paid, you would need to have each of those sections filled out because you can't change that information unless... I don't think you need to have each of it. You need to have, you're going to want to have it if the listing brokerage firm is paying you, you're going to want to have that in there so that it's clear to the seller, clear to you, clear to the listing brokerage firm. If your seller's paying you, you need to have that in there because that's the only way you're going to get paid by the seller is if it's in 29.1. To my question, or to the answer I just gave, to the extent that it's just 100% your buyer is paying you, then I suppose you could leave it out of that agreement and not disclose it because you've got a separate agreement, which is your exclusive right to buy or the compensation agreement with your buyer. And that would be independently enforceable, irrespective of whether 29.2 was checked or not. So when does this change? Section of 29, it's August 15th. All of these red lines will become mandatory and in all of the forms beginning August 15th, 2024. Why should a compensation of buyer broker by buyer be disclosed? Same answer I had before. Why should 29.2 be? Again, don't do it. But if you're not going to put it there, then make sure that you've got a very clear email after the fact explaining, hey, buyer, seller is not compensating me, listing broker's not compensating me in this offer that you're writing. You are going to be obligated to compensate me X, which is what is in the success fee. Is it redundant? Probably. Because you've already got an agreement with them. Is it redundant? Yes. But I guess in that case, if that's what your buyer's perspective is, then also you're going to be checking the box, buyer will pay. So not the box that says buyer is obligated to pay, seller or listing brokerage firm may pay. If that's checked, then I think you've got to put it in the offer. Otherwise, because they're instructing you to ask for it. But if you're going to check the box, buyer will pay, period, nobody else's business but mine, then do that. And I don't think you got to do anything with 29. I thought we couldn't go back and ask for more commission. You can. You're going to have to amend your agreement. So thanks for bringing this up, actually. So remember, you can only take what your buyer is obligated to pay you. So if your buyer is obligated to pay you X, and the listing broker or seller is offering X plus 10, whatever that might be, you can't take that plus 10 unless you go back to your buyer and re-execute or amend your exclusive right to buy that now says that your success fee is X plus 10, or you do a new compensation agreement with the broker disclosure document. So that's just ties back into my whole point. You can only take up to the amount that your buyer has been obligated. You could amend those agreements with your buyer if they're willing to do that. But remember, they're not going to be necessarily obligated to do that. So that's why I think the best practice here is decide as a buyer broker, this is what I work for, buyer. This is what I charge. This is how I put food on my table for my family. This is how I pay my bills. My fee for representing you as a buyer is X. And that's what you put in your success fees. I think that's the way to do it. And then this less, more stuff, it kind of goes away if you're really willing to dig your heels in. And I know that's impractical in some ways, the way we've done business in the past, but those days are over. And I wish I could tell you differently. Will there be an example or a form provided that is an agreement that is referenced to here? I think that's probably everything I went over. So the compensation agreement is maybe what you're asking about. Why is an outside agreement of any concern to a seller? Same answer. And I get your concerns there. Again, leave it blank. If you've checked the box, buyer will pay, period. That's it. Then leave it blank. But I don't know how many of you guys, I have trouble getting, for years, brokers have just been saying buyer's not obligated to pay, checking that box. So now you're going to go from buyer's not obligated to pay to buyer will pay, period. This is it. If you've got that check, then you can leave 29 blank. But if you've got seller listing brokers firm may pay, then you're going to need to put in that offer what you're getting, and therefore what the buyer might still owe you based on the fact if it's less than what you're getting from the seller or listing broker. So I don't know. I get it. If you have a buyer agency with an agreed buyer agency fee, are you required to disclose that? Everybody's hung up on that. I get it. You heard my answer. All of you guys asking this question need to get comfortable checking the box in your exclusive rights to buy. Buyer is obligated to pay, period. And listen, you're my hero if you're doing that. Say, buyer, I don't care. You're paying me. This is what I work for. You're cutting me a check at closing. Here's our agreement. Simple as that. If buyer pays for a commission, will lender allow this now? I think lenders will allow compensation to buyer broker. They're not going to allow them to finance it in to the purchase price. I mean, that's where things get weird with the seller concessions issue and how things are structured. Listen, this is one of the problems that we always deal with lenders. You could go out to 100 different loan underwriters out there, and you might get 100 different answers in terms of what's allowed or what's reasonable or whatever. I will say this, on the VA side of things, this was a big issue. VA buyers specifically are precluded, and they still technically are, under federal law from compensating their brokers. They're not allowed to compensate, as most of you guys know. So what the VA has essentially done is they've suspended enforcement of that rule until they can do some additional rulemaking. So while they didn't actually change the rule, they issued a very formal press release. I've got it somewhere here, saying we're suspending enforcement of this rule. And so that'll allow, at least for the time being, until my guess is they'll go do some rulemaking that will then allow it on a permanent basis going forward. Which option would we use if our buyer's agreement says X amount paid by seller, buyer not obligated? You would use the 29.1, which seller agrees to pay, unless whatever your buyer, well, but first of all, buyer not obligated is gone. Okay, so that's as a premise, buyer not obligated is gone, effective August 15th. It's still there now. August 15th, that box will be gone. But if you're going to use whatever you expected, or whoever you're expecting to pay you, it's either got to be in the contract if it's a seller, got to be in the exclusive right to buy if it's your buyer, or it's got to be in a compensation agreement if it's the listing broker. It's very possible that my compensation pre-agreed with buyer equals X and the seller agrees only to pay 75. What is the point of filling in 29.2 to indicate the excess the buyer is paying me? That's already been addressed in the buyer agreement. Isn't the whole point of antitrust issues that none of the seller? Well, it's not the point of the antitrust issues. So those numbers need to add up to what you're being compensated if it's by more than just the buyer, right? That's why 29.2 is, because we know that you're allowed to take up to, but not more than. And so if you're going to have seller is going to be X, it is going to be, love you guys. If your seller is going to be, if the seller's going to pay you X, and that is, 5 things less than what your buyer is obligated to pay, then paragraph 29 needs to say seller's paying you X and buyer's paying you plus 5. And that's for disclosure to your buyer that they have this additional obligation over and above whatever the contract is obligating you for. So again, if you're concerned about disclosing this, I'll make it easy for you. Buyer is obligated to pay, period. Do it in every one of your exclusive rights to buy. Discussion over. But make sure you're also sending an additional writing to your buyer before they go under contract on that property to say, just letting you know, I don't even know if it's so required in that place, to be honest with you, because quite honestly, you do have a standalone agreement. The buyer is going to pay you at closing, period. So if that's what you want, do that, and more power to you. I love it. Scott says this is what we use to include in our success fee. We may be writing offers blind when a listing agent doesn't respond. Yeah, I mean, that's the other thing I'll mention real quickly with these compensation agreements is that you got to be very, very careful. You're going to be reaching out to listing brokers if it's not otherwise obvious that they're offering compensation or what they're offering for compensation. Put it in the contract. Put seller is obligated to pay. Make it a part of the offer. 29.1, seller's obligated to pay. put whatever your buyer's obligated to give you there, and just put it in the offer. I'm concerned that anybody's using a compensation. Let's say you've got a multiple offer situation and you got buyer brokers who are sitting on their hands going, well, wait a second, I don't want to submit my buyer's offer to the seller until I get this compensation agreement executed by the listing brokerage firm. Well, guess what? You're probably, I'd say you're in breach of your fiduciary if you're doing that. In other words, your buyer is looking to get this house under contract. So in that case, just put it in the offer, check the box, seller will pay. And remember, if the seller accepts that offer, then we change the exclusive right to sell listing agreement to say that whatever the seller's agreeing to pay is going to reduce what they're obligated to pay to the listing broker. So it probably shouldn't really matter to the listing broker, and the seller's not going to have double obligations in that case. So if you're in that situation, check 29.1, put the amount into the seller's going to pay you. You're a third-party beneficiary, and that's the best way to get paid. If ERB has hourly or retainer box check. I mean, I don't know how you do that. A retainer box or hourly is, yeah, I don't know. I'm going to punt on that question because I don't know how you memorialize that in the compensation. I mean, you're going to be writing an offer and you've still got all this work to do. I don't know what's your hourly rate going to be? Are you going to be able to say, okay, the rest of this transaction is going to take me, exactly 27 additional hours of my life, and at an hourly rate of $100 an hour, that's $2,700. I mean, I don't know how you're going to do that in the offer. I'm not saying you can't do it. You're free to structure your compensation with your buyer however you'd like. But you do need to have a definitive number, I think, in the contract. The seller's going to want that. The buyer's going to want that. The listing broker is going to want that. And so that's probably going to be problematic if it's a retainer fee. Can fee be more if you add more into buyer agency? Yes, ahead of time. No, if you're adding more ahead of time, that is not an objectively ascertainable agreement. So that doesn't comply. You need to have X is your success fee with your buyer. If the fee ultimately is going to be X plus 2, then the plus 2 needs to be amended into your contract with your buyer. Can we accept less without any major addenda? Yes. I don't think anybody's going to complain if you're going to accept less. Irony is funny that way. Can commission be less than the buyer agreement? Yes. And your recommendation on the verbal or written agreement between realtors? Listen, written agreement. I think, the statute of frauds doesn't apply to commission agreements. So I suppose you could maybe create a verbal agreement for commission. I don't know how you enforce it. I don't know how you arbitrate it. I mean, if somebody came to our arbitration process saying they agreed to pay me and we had a verbal agreement, I don't think that survives because that's not unless there's evidence of a contract. I don't think that gets into the realtor arbitration process if you actually had a dispute. I think you could have a series of text messages. I think you could have a series of emails that would create enough to arbitrate and to enforce as a contract to pay you. But it's not the best. The best is going to be to use the compensation agreement between the buyer or between the listing broker and the buyer broker, or to put the seller's compensation to you in the contract to buy and sell. That's going to be the best, the cleanest, the clearest, the best way to do that. If you're relying on something less, you might be getting something less. That's going to be a case-by-case enforcement question. So the main difference between 29.1 and 29.3 is the seller versus listing broker to pay. So if the listing brokerage is offering a co-op, would we check 29.3 and not be offered, but trying to negotiate with the seller to pay the commission? So yes, I mean, I think you can always be safe if you don't have a written compensation agreement with the listing brokerage firm at the time you're writing your offer. If you haven't had a mutually executed agreement with the listing brokerage firm, then I think the best bet is to put it in the seller will pay you. Because we know with the revisions to the exclusive right to sell listing contract, if the seller signs that contract to pay you, Y, then Y is going to be reduced from whatever they've agreed with the listing broker that they could offer to you otherwise. So I think that's the best way. But if you have a written compensation agreement already existing with the listing broker, in that case, then you could just use 29.3 and put it in the contract there.
Hey, Scott.
Hi, Holly.
We are about half an hour over. Do you want to, a handful of us have to jump off for another standing meeting at 1 p.m. Do you want to keep going for half an hour?
Well, we still have in excess of 2,200 people in the room. I'm happy to keep going for another. How about if we set a time and I'll go for another 15 minutes?
Okay, that sounds good. Another 15 minutes. And then we
Does that
gotta,
work? Yep. I'm going to have a hard stop at 12:45.
okay, that sounds good.
Does that work for everybody? All right. All right. Sorry. I knew there'd be a lot of questions. I just didn't figure there'd be this many. You inquisitive bunch of realtors, you. Let's see. I understand that the total broker buyer agent compensation cannot exceed. However, who is going to be looking at the ERBs to verify what amounts are in there? Until now, the ERB is just between, it is still between the buyer and buyer agent, period. The ERB is. And so who's going to be looking at it? Well, to the extent that there is a complaint filed with the Division of Real Estate, that agreement is subject to audit. And to the extent that the broker has taken more in violation of that agreement, then that would be subject to discipline. To the extent that there is an MLS complaint, then the MLS has a right to request a copy of the buyer agreement based on their rule changes. And so it'll be the MLS's disciplinary process that would kick in that case. Again, I think, guys, we have to get comfortable with the fact that enough brokers are going to be wise enough not to be doing things that are inconsistent with the legal contracts that they have executed with their respective buyer or their respective seller. And the rest of it's going to be a matter of enforcement. If you're closing on a current under contract, say August 19th, do we need a new contract created over the current? No, the current's going to survive. Remember, the offer, I think the offer of compensation is through the MLS as it currently exists and has existed. You earn that at the time of contract. And so I don't think you need to do anything on before August 19th in terms of, I mean, if the listing brokerage firm wants to sign a compensation agreement with you, memorializing that, I think that's fine. If I'm a listing broker, maybe I'm willing to do that. I don't know, but I think that for our purposes, the CAR would entertain arbitrations for essentially procuring cause disputes through any transaction that was initiated prior to August 15th, 2024. And so I don't think you need to do anything. If you want to and everybody agrees, great. Don't amend the contract, by the way. Do not amend the contract between the parties to do this. Just do a compensation agreement or do something else if that's what you want to do. But I do think you have a right to enforce that offer of compensation, particularly if you've already gone under contract. What is builders pay bonuses? Why can't you write in the case new slides? Is selling company pays different commission? I don't know. Bonus, no matter what, as a buyer broker, you are only eligible and allowed to take what your buyer has compensated you. You can take no more. Remember, the exclusive right to buy used to say that you were entitled to take those things. It no longer says that. It says specifically you are not entitled to take those things. And same with the compensation agreement at the broker disclosure to buyer. So this is going to be the problem here. It's not just your MLS rules that have an impact there. This is your state license law, your fiduciary relationship, or uniform duties to your individual client. I think I've answered the 29.1 versus 29.3 question a bunch. Would Scott mind giving us an example of why an agent would want to check all three boxes in provision 29? Well, sure, that you've got sellers going to pay. So let's say your buyer has agreed to pay you A compensation, and A is the most of my example. You might have a situation where the seller is agreeing in the contract to pay you X. The buyer is agreeing in the contract to pay you Y, and the listing brokerage in the firm is in the contract has agreed to pay you Z through. So you've got an agreement with the list compensation agreement for Z. You've got in the contract, seller is going to pay you X, and you've got an exclusive right to buy that says the buyer is going to pay you Y. So X, Y, and Z add up to A. In that case, you would have all three boxes checked because you're entitled to collect A and you're getting it from three different sources: seller, buyer, listing brokerage firm. If those all added up to A, then they would all three be in the contract to buy and sell. Do we have to redo our exclusive right to sell? I hope I've answered that question. If you need to, you need to. But really, unless you're a listing broker and you're modifying your compensation for some reason with your seller, or the cooperating compensation with the seller, or you have a exclusive right to buy and you've checked buyer's not obligated to pay, or TBD, or not less than, or some range, you would need to change those, or amend. Do you need to do an amend extend? Is this an acceptable clause that can be used in the buy-sell contract? X or blank, but not both. I didn't see your clause in the first question. X blank, not both. Yeah, I don't know why you do both. It's going to be, you're either working for a percentage or working for a flat dollar amount. Either one is fine, but I don't really see a scenario where you get a percentage and a dollar amount both. So I think it's just one or the other. Will existing contracts be grandfathered, or will we have to? If the MLS cannot list the compensation for a specific listing, how can we find out what the compensation is? Just ask the listing agent. Yes, or on the listing firm's website, sign writers. However, here's the deal. I think it behooves listing brokers to figure out how you're going to communicate this. Otherwise, as a listing broker, your days and nights are going to be spent on new listings or on current listings, answering calls or emails or texts from brokers saying, hey, are you offering compensation? How much? Are you offering compensation? How much? We sign an agreement. How much? We are. So it behooves listing brokers to figure out a process that you're going to distribute your offers of compensation that is not on the MLS. And for the time being, certainly, I would not be part of one of these aggregator websites. It just feels like you're asking for trouble with those right now. Is it an acceptable clause? It's not there. Does 29 in the contract to buy and sell count as an agreement between listing company and buyer's company? No. The agreement between listing company and buyer's company is the broker compensation agreement promulgated by the Colorado Bar Association, or some other agreement between the two. But hint, hint, use the broker's compensation agreement as promulgated by the Bar Association. Is the full amount of compensation still put in the first section of the exclusive right to sell in section 7? Yes, exactly. And so let's say you're a listing broker, that's your full compensation. And let's say they've agreed to offer you, your sellers agreed with you that you can offer X compensation. And let's say that the buyer who brings, or the buyer broker who brings a buyer is getting X minus 9 apples with their buyer. And so that's all the offer is for. Well, those additional 9 apples, those belong to the listing broker now, because the buyer has only authorized their buyer broker to take X minus 9 apples, and your total compensation with your seller is still, X, including the 9 apples. So I hope that makes sense. At the time of the closing, seller will, on behalf of buyer, pay. Sorry, I've got old man eyes. I can't imagine how silly I look leaning into the camera every time. At the time of closing, seller will, on behalf of buyer, pay directly commission of X to fulfill buyer's contractual obligation to buyer's broker for a total. Oh my goodness. This is in no way meant to imply agency relationship between seller. This is why you're using paragraph 29. These clauses that you guys have been using to put into the additional provisions for some years, requesting compensation, maybe because you're not a member of the same MLS or whatever, those you don't really need anymore because you've got paragraph 29. So I think that's what you're saying. I don't think you're going to be putting those in the additional provisions anymore. I'm confused on 7112. If you only negotiate your compensation and not the buyer's broker, but in this seller pays the buyer's broker, it seems that. No, I think the exclusive right to sell addresses that. It says that it's going to be offset by any compensation the seller pays directly to the buyer's broker, which is why I'm saying that paragraph 29.1 works as long as there's not a commission compensation agreement and paragraph 29. That would be, I think, a problem, is if you had 29.1 seller's going to pay, and then you had a separate agreement for the full amount of whatever the compensation is with the listing brokerage firm. But other than that, the seller doesn't have that double exposure. An exclusive right to sell, can you strike through 711 and 712? I can't open up the forms again to answer that question. I'm sorry. Is this an acceptable clause that can be used in the buy-sell? I still don't see an acceptable clause. I'm not seeing any clause there with the question. What is the new law regarding post-closing? I'm not doing that now. Can you amend your agreement with the buyer if seller is offering more? Yes. Is 7.1 half of X, or just it's whatever is in 7.1.1? It doesn't have to be half. It can be anything. It's whatever in the exclusive right to sell. It is whatever your seller is agreeing with you, the listing agent, that they are authorizing you to sign a broker compensation agreement and offer to a third-party cooperating broker. Does it have to be half? Absolutely not. Absolutely not. It's whatever is in that agreement that you have with your seller, that they have authorized you to enter into an agreement with a third party, in this case, the buyer broker, to pay them at closing. If buyer's agreeing to pay the buyer compensation and buyer is not represented, would listing agent get entire? Yes. I mean, in that case, there's not a cooperating broker. So if that's not somehow accounted for in the contract, then yes, the entire amount of compensation is paid to the listing broker. Yes, 7111 is total compensation, and then that clause down below offsets it by whatever you're offering or authorized to offer. Exclusive right to sell. Can the parties agree to a certain compensation? Sure, I think you can have an additional provision that would essentially create a variable commission or something, variable compensation. Yeah, I mean, that could go in there. There's nothing wrong with that. How do we modify existing listing and sales contracts? Is there an addendum? You don't need to modify the agreements. Don't modify the existing agreements. Remember, those are between the parties. So start using the new contract as mandatory on August 15th, and the new agreements as mandatory on August 15th, and that's where you're at. Otherwise, you're relying on up to August 15th, you're relying on what you've been relying on for generations, and that's the offer of compensation in the MLS. I'm just trying to scan through these. Guys, I'm overwhelmed by the questions, and we've got 4 minutes. Can we put in the buyer agency that the buyer will cooperate with the buyer's agent if the seller changes their mind not to pay compensation? Well, this is an important point, actually, and I don't know if this is your question, but let me point this out. If for some reason you have signed, as a listing brokerage firm, you've signed a compensation agreement with a bunch of different brokers out there who might bring you buyers for X%, and then your seller says, no, we're going to amend our contract, we're going to reduce that. I think you've got to go, then now you've got to make sure that if any of these people you signed agreements with have written offers, that you're addressing in paragraph 29 the amount, and you're signing an updated compensation agreement with the broker who you're actually going under contract with. So do be aware of that if you're doing an amendment to your exclusive right to sell listing agreement with your seller and reducing the offered compensation or the amount that you're authorized to enter into a broker compensation agreement with, you're going to have to make sure that any of these existing agreements are modified before you allow your seller then to accept a contract coming from one of those brokers with whom you've already agreed to a different compensation number. So do pay it. I mean, it's not like you can just sort of willy-nilly sign these things and not just lose track of them. You need to be I would encourage this. I would encourage listing brokers to not sign the compensation agreement, to go ahead. Either buyer broker can prepare it and send it over to the listing broker with the offer, or at the time of showing or before the showing or whatever. And then listing broker can sign it, and now you've got an agreement. Or to send out a blank one that you haven't signed. That you could fill in your terms that you're offering, the percentage or dollar amount, but don't sign it and send it to them. That way they got to sign it, send it back to you, and then you can sign it, and you've got a way to track these things. Because I don't think you just want, just a whole bunch of these things floating around, even though it really is only going to be confined to the broker that tenders the offer and actually closes the transaction. I think it's still, you still could have some issues if you are, if you're not tracking, who you have these agreements with, and then trying to account for that in paragraph 29 as you're actually getting an offer and making sure that everything's consistent. So anyhow, I'm going to take 2 more questions, then I'm done. If the seller is offering the listing agent X and the buyer's agent X, but the buyer's agent is asking for X plus 1, the sellers, I can't. I'm sorry. Call the hotline. The hotline's a great resource for some of this stuff. I don't call it today because I'm talked out and I'm actually answering this afternoon. But it's sometimes easier to talk about this over the phone than it is to try and read questions. Can compensation still be displayed on the MLS that are not owned? Yeah, I've answered that. As listing agent, if we double side the transaction, then we are working with the buyer as a customer. We still unjust use broker disclosure. Yes, you're a customer. So you don't have a compensation. Thank you for that. So in that case, you're going to give a broker disclosure to buyer. You're going to check the box, seller's agent, buyer customer, no duty, no compensation agreement with the buyer needed there because your compensation is dealt with as the listing agreement with your seller. That's already done. All right, last question. So if the builder offers bonuses, we tell the builder not to pay it. You can't accept it unless you either, so yes, you're going to tell the builder not to pay it, or you're going to do an amend extend with your buyer to update your agreement that authorizes you to accept whatever bonus you're being offered. Thank you guys very, very much for hanging in here on, what is this, 2 hours and 15 minutes this morning. Thank you to CAR staff. I'm sorry I can't get through all the questions. I will be as responsive as I can on the legal hotline and other places, and I'll try and continue to do education to answer the questions you have. I just want to say before I close, please, guys, the imperative point you can take away from all of this is that the industry has changed despite everything that you've been doing. This is not your fault. This is the world that we've been left to live in. And the best thing that you can do, particularly as buyer brokers, because as listing brokers, sellers brokers, you've been doing this for a long time, is focus on your value, respect yourself, pat yourself on the back, pound your chest about what you do. You do so damn much in connection with the transaction. And this is the time that needs to come out as we're going through these changes, and consumers, both buyers and sellers, need to respect what we do, what you do as realtors in a transaction. And it's that premise, that mind shift, that mindset shift has to start with you respecting yourself, respecting each other, respecting what you do. Thank you guys very, very much. I think Jason wants to say something very quickly, and be well.
Once again, Scott, thank you very, very much. We are very blessed to have Scott as not only a realtor, but our general counsel. If you go around and tout any value that the association gives you, is Scott himself is absolutely wonderful. We appreciate that. So in closing, just remember that this recording will be available on the CAR YouTube channel tomorrow. Best practices, if I can give anything to you, is take this, rewatch it, get with your brokerage, get with your team, set a standard for you and your team on how you're going to move forward. We've got a great recording, rewatch it as many times as you can. Second, Scott already mentioned this, the legal hotline. Tomorrow you start having questions, give him a call. We'd be happy to help. We are here to help you be successful. You are great. You are community builders. You are doing great things out there for your clients. Keep doing that. We appreciate you. We love you. We're very grateful for all that you do. So with that, go and seize the day. Make it a great day. Again, thank you, Scott, Holly, and all of your team that has made this successful. We'll talk to you guys soon.